Take a minute while Mr. Manny figures it out, huh? You look pretty good, Mr. Manny. You're muted, by the way, so you need to unmute. Can't hear you, Mr. Manny. There you go.
Okay, thank you very much, Judge.
There you go.
Hope springs eternal, you know, maybe I don't know what happens.
We all struggle with it. Don't feel bad.
Yes, it's probably a function of age.
I'm just glad it was you today and not me.
Manny, I've known you a long time, and things were very different back in those days.
May it please
All
the
right.
court. By now, you know, I'm David Manny, and I'm here to represent the interest of Mrs. Johnson in a case with which you, Judge Northcutt, are undoubtedly familiar since you wrote the most recent opinion in it. But let me give you a little quick background. This case started back on March 19th of 2009. 2009, not 19, but 2009. And that's when the former husband obtained a final judgment against his former wife based upon a settlement agreement he had prepared. There was no appearance for the wife in connection with that agreement, although, interestingly enough, there were some findings later made by Judge Stevens with respect to the conduct of the present attorney, Mr. Larson. It was found that in the eventual opinion after a 12.540 was filed that Mr. Larson had indeed given her legal advice with respect to her action on the settlement agreement proposed by the husband. In March 25th of 2009, the wife began to wise up, and she filed a motion to set aside the final judgment, which had been procured by her husband. On July the 19th of 2010, there was an interlocutory order entered by the trial judge in which he made certain findings of fact and conclusions of law, in which he said gave the husband an opportunity to reply. The husband did not reply adequately, and on November of 2010, final judgment was entered by the trial judge. Normally, I wouldn't burden the court with a recitation of what the trial judge had said, but this case I am. I cannot resist the temptation to tell you what was at stake there. In setting aside the judgment that had been procured by Mr. Larson's partner, the trial judge made the same thing. Now, I cited this on page 4 of my initial brief and on page 1 of my reply brief, so bear with me. More disturbing is the fact that the only legal advice the wife received was from her husband's law partner, Mr. Daniel Larson. And that advice was not to get a lawyer, which in this case was very bad advice. The husband's partner denied having given legal advice to the wife, but there is no question he did. He admitted that. All the while, he maintained she should not consult a family lawyer, a family attorney. He repeated scandalous stereotypes about the family law bar. He actually used the word churning in his testimony. Once the wife was advised she was going to see an attorney against his advice, he stopped talking to her altogether. Then that's a factual finding. Judge Stevens then went ahead to give you the legal basis, in which basically I'll read the first sentence of his legal opinion. Telling a person whether or not she needs an attorney is giving legal advice. And he cited this court's opinion, Buscemi against Matakai, I think the word is, at 730 Southern 2nd, 329. And then
Mr.
the court
Manny,
yes, sir.
That information that Judge Stevens put in his order is so compelling, it's hard not to forget if you read the file in this case. It's just it's overwhelming. Yeah, I mean, it's a shocking litany of things. But I think we all know that when Judge Stevens made these statements in his 2010 order, he had not had the opportunity to review or even know about her deposition in December of 2011, where she basically said that Mr. Larson did not represent her and did not give her legal advice, irrespective of the advice he gave her not to get alleged advice he gave her not to get a family law lawyer. So she herself says, Mr. Larson never represented her, and he didn't give any legal advice. So, I mean, we just ignore that?
No, sir. You are not to ignore that. You are to read it carefully. If you read the question that was asked by Mr. Larson when he sued me and her in his slander case. He said, at the time that this advice I gave you, I didn't represent you, did I? At the time. He didn't ask the next question. The next question was, did you later find out that I did represent you? And the answer would have been yes. He never asked the question. It was left dangling. And I think that's one of the reasons that he dismissed his suit against us both and never did anything about it. I would urge you to read that language that he quoted carefully. It wasn't in this case, by the way. It was in a separate case, and read the language carefully. If you do, I submit to you that you will come to the same conclusion I did. He didn't ask the right question. I didn't attend that deposition. I'm relying strictly on what I read in the transcript itself. But I make that point in my reply brief. She answered the question truthfully. She's a very intelligent woman, and she answered exactly the way he asked it. At the time this advice was given to you, believe he represented you? And she said no. Now, he didn't ask the next question. Did you come to believe he did? Absolutely. That's why she finally went to an attorney 16 days, and he's calling her every day, telling her, go along with your husband. I'm sorry, sir, go ahead.
What about, I mean, it's troublesome also that it took a whole year for her to actually make this motion. She had knowledge and information of all this. It took her an entire year after a lot of work was done, a lot of prep was done. And as you know, the cases basically don't want that to happen. If you're gonna bring in something like this, you need to bring it right away when you know it, so you don't have some guy who's put all this time into a case and now they're off.
Okay, the only thing that was pending at the time that Mr. Larson, now he filed 2 notices of appearance. He didn't reveal that in his brief. The first notice of appearance, the one he wants to rely on, he filed and said, I'm going to represent my partner. Only thing that was pending at that time was the issue of my appellate attorney's fees, where I had once again won the case on appeal, from which I'd taken appeal on that one. That's the one that Judge Northcutt reversed the trial court. While the case was and the judge, your court granted our motion for attorney's fees, and then he filed a notice of appearance at that time. That was on the trial. Later on, he filed a second notice of appeal, which is the one that's relevant in this particular instance. He filed a second notice of appeal and said, oh, I'm going to file a notice of appeal. Now he filed that one on May the 12th of 2019, not November the 8th of 2018, which is when he filed his first notice of appeal. When he filed that second notice of appeal on May the 12th, notice of appearance on May the 12th of 2019, that's true. That's the measuring date. We didn't really care if he came in at that point, but he then filed what I would regard as a specious motion for fraud on the part of the wife. That changed the whole complexion of the case. And at that point, he filed that motion to disqualify. I filed a motion to disqualify on November the 25th of 2019, after he filed a motion to her for she had committed fraud on August the 25th of 2019. Now, the only thing I can say is, why didn't I file it on August the 26th? Answer, I had to discuss it with her and see if there was anything with it. And by the time I could discuss it with her, I immediately filed my motion to disqualify him on November 25th, 2019, barely 2 months after he had filed the first meaningful action on his part, which put him out of the case. At that point, we didn't want him in there. I would agree with you. Normally, you want to do something immediately about that. But in this particular instance, especially considering this case is now 11 years old, you have to look at the overall picture of what we were confronted with at the time. Now, recognizing that was a problem, I want to point out another point to you. Judge, we had him testify in the first trial. He is the business partner of the husband. He is a sharing partner. I'm talking about business for profit. He is a co-owner of land with the husband. He is his partner. We had to testify last time in extenso about these matters. So we gave, at the same time we filed a motion to disqualify, we gave notice that we intended alternatively to call him as a witness in the case, just as he'd been a witness in the previous case. The whole thing was a little shocking to me too, that an attorney would represent his partner when he knew he was going to have to testify. And his response to that was, oh, I'm going to have, you could call somebody else to establish those points. Who better to call to establish the value of the businesses that he's involved with, the income of the businesses that he's involved with, and the fact that he's been a partner with the husband all these years, even down into the tobacco litigation, which we're going to get into, then he is the appropriate person to call. He's not an incidental witness. He is a major witness. He's not being called to disqualify. That wasn't even on my mind at the time we filed a motion for his disqualification, although certainly it's apparent that we were going to call him. The fact is, and I'm glad you recognize it, this is an incredible behavior on the part of this attorney. And it's a kind of behavior that cannot be rewarded on a doctrine such as waiver. But in any event, I see you have exactly what I had in mind. That is, it's very, very troublesome. The idea that you can assert that you're not going to, that you're not testifying when you're advising your partner's wife not to get an attorney and to say the things that he said. Now, this issue has been decided by the court. I grant you that. The only issue that's really available for them is waiver. And I don't think that waiver is an issue that's available here, especially in view of our having taken his step and a view of our having asserted that in addition to his behavior representing, that can't have been waived, whereas here he is going to be a witness in the case. They meld together. I'm not going to tell you it's black and white, but I am telling you that the trial judge below, of course, totally missed the boat when he wanted to talk about credibility. That credibility is not the issue in this case. That's an issue that we resolved at trial. The motion for fraud on her part was just denied. It wasn't even up before this court. It shouldn't even be considered. The only reason it's going to be considered now is the fact that it showed why we delayed the case. But anyhow, you look so interested, Judge. I mean, I'm not much on this electronic stuff, but I think you see where I'm coming from. If you don't have any further questions, I'm not prepared to go any further. I think we'll either stand or fall on the issues that you and I have now just discussed. But I will say one thing. This case has been delayed and delayed and delayed. There has not yet been a successful appeal made by the husband. He's taken it up to the Supreme Court of the state of Florida. He missed. He took it up before Judge Northcutt and his panel. He missed. He's taken it up before per curiam affirmance. This is a case where we are entitled to have the case tried by an attorney who is not representing his partner. That attorney is going to be a witness. That attorney has been found to be, let's just say, I don't want to say untruthful. He disagreed that what he was doing was giving legal advice. Judge Stevens said you were giving legal advice. So the only way we could have him stay on is for you to say, somehow this wife has waived her right to have her case tried by an impartial attorney. And I think that far outweighs any consideration you might give to him on behalf of a claim of waiver. Thank you, Judge.
Mr. Manning?
Yes, sir.
I said thank you. Okay.
Oh, thank you, sir.
It's all good. Mr. Anderson?
May it please the court, I'm Scott Anderson. I represent the respondent and former husband, Mark Johnson. I'm with the law firm Johnson, Dable, and Anderson. And I'd like to start off by talking about Mr. Larson and his reputation as a lawyer. He's been practicing before Florida courts for more than 30 years. He's an AV-rated lawyer, practices by the highest ethical standards. He did not give legal advice to the former wife. He still takes that position. He testified at the hearing below, the transcript of which was not provided in the record. He maintains that position. Judge Loeffler's order below should be affirmed for a number of reasons. And the first being one that Judge Morris pointed on briefly, which is the former wife waived the ability to bring this motion. These motions are frowned upon, and they're an extraordinary remedy that should be used sparingly. They must be made promptly upon knowledge of the issues that give rise to them. Secondly, there never was an attorney-client relationship between Mr. Larson and Ms. Johnson, and the law of the case does not require a finding otherwise. In fact, law of the case doesn't apply at all. The third reason that the opinion below should be affirmed is that Mr. Larson is not a necessary witness under the applicable rules or the case law. And we'll discuss all of that. Finally, and most basically, former wife did not provide any adequate record to support reversal. There's not a record of the hearing below in which she testified and Mr. Larson testified as to what legal advice or what advice she was given. whether or not that advice was legal, whether or not Mr. Larson ever represented the wife. And we'll discuss all of that, and I'd like to start with the waiver. The case law is clear that even if there is a basis for disqualification, which respondent strongly feels isn't the case here, that motion must be made with reasonable promptness. That was not done here. Mr. Larson filed a notice of appearance on November 8th, 2018. It wasn't a limited appearance. It didn't restrict his appearance in any way. It was a general appearance and instructed all the parties in the case to give him notice of all pleadings, all documents, and all correspondence. It wasn't limiting.
Why did he file a second notice of appearance?
The notice of appearance that was filed in May of 2019, Your Honor, simply removed Mike Jones, who was a former lawyer at the law firm. If you'll notice, the first notice of appearance filed on November 18th of 2018 included both Mr. Larson and Mr. Jones. Mr. Jones left the firm, and out of an abundance of caution, Mr. Larson filed another notice of appearance removing him from future pleadings, etc. But in no way was the November 18th, 2018 notice of appearance limited in any way. More than a year later, the motion to disqualification comes. The case law is clear, and it's discussed in our brief, that once you have noticed that a potential basis for disqualification exists, you need to move promptly and exercise that. Here they waited more than 12 months. The case law cited by the respondent in his brief, specifically the Transmark USA case, found that 10 months was too long. And in that case, it was undisputed that the attorney representing one of the parties had previously represented the other party in the same litigation related to the same issues. And they waited more than 10 months to file the motion to disqualify, and the court specifically found that it waived the ability to do so. And importantly, the motions to disqualify are not to be used to gain a strategic litigation advantage. As Mr. Manny explained to you and as explained to on page 7 of his brief, it wasn't until the former husband's chosen counsel, Mr. Larson, filed a motion for fraud outlining representations made in the trial court related to Ms. Johnson's ability to work, related to representations made to this court about Ms. Johnson's ability to work, that he filed the motion for fraud. And on the heels of that, former wife moved to disqualify him. And on page 7 of Mr. Manny's brief, the former wife's brief, they admit that that's why. And I quote, "It was not until the former husband, through Mr. Larson, made an assertion of fraud on the part of the former wife that the former wife objected to the representation of the former husband by Mr. Larson. The former wife objected to the continued representation of the former husband by Mr. Larson, the business partner, fiscal officer, a co-shareholder of the firm. It was then clear to the former wife that Mr. Larson intended to pursue what she sees as a baseless claim." This rationale is the exact rationale that courts around the state have found is an improper basis to seek disqualification. Mr. Larson appeared on November 18th of 2018. He conducted discovery. He reviewed significant discovery. The docket which was provided to your honors shows that there was lots of discovery happening. There were notices of depositions taken. Mr. Larson reviewed all of that information, reviewed all of the discovery, reviewed all of the financial information that had been provided over the last 10 years of the case, and filed a motion for fraud based on that. It was not until then that the former wife moved to disqualify him. The notice of appearance filed in May was simply to remove Mr. Jones from the certificate of service because he had left the firm. Moving on to the second reason that the judgment should be affirmed is Mr. Larson never represented the former wife. Frankly, there's no evidence in the record on appeal or in the record of the trial court that such a relationship existed. The former wife instead points to an order from 2010 made by Judge Stevens and asserts that it is somehow law of the case that Mr. Johnson and Mr. Larson and Miss Johnson had an attorney-client relationship. She's simply wrong for a number of reasons. The first is Mr. Johnson or Mr. Larson testified at the hearing before Judge Stevens that he never did give her legal advice, and Miss Johnson testified the same. Judge Stevens made a finding of fact, and Mr. Larson did disagree with it and continues to disagree with it. And both parties testified to that in the hearing below, which was not provided. Furthermore, the law of the case doctrine simply doesn't apply here. The Florida Supreme Court has repeatedly explained that the law of the case doctrine is limited to rulings on appeal that are related to questions of law that are actually presented and considered on formal appeal. That's simply not the case here. And we look no further than former wife's reply brief on page 4, where she recognizes this is a factual issue and it was never raised on appeal. Law of the case does not apply. And as the Florida Supreme Court also recognizes, a corollary to the law of the case doctrine is that a lower court is not precluded from passing on issues that have not necessarily been decided and become law of the case. The Florida Supreme Court found that in the Delta Property Management case cited by Mr. Manny, and also found it in the Florida Department of Transportation case v. Juliana cited by former husband in his brief. It simply does not apply. It was not a finding of law. It wasn't a conclusion of law, and it certainly wasn't necessary to this court's PCA of Judge Stevens's prior ruling. It simply doesn't apply. The Supreme Court has made clear that in order for law of the case to apply, the facts need to remain the same. And as Your Honor, Judge Morris pointed out earlier, there's been depositions that have taken since that contradict those are the facts. There was a hearing below in January that contradicts that those are the facts. When the facts change to the extent that the law of the case doctrine even applies, which it doesn't, it's no longer the law of the case. And that's especially true, whereas here, the finding of law, if it even is one which we disagree with, was not necessary to the appellate court's ruling related to the prior trial court's ruling. Judge Stevens wrote an 18-page opinion that cites 15 pages of facts, and this honorable court PCA'd them. It's impossible for this court or any court to be able to say that the finding of fact made by Judge Stevens related to any sort of representation agreement between Mr. Larson and Miss Johnson was a necessary finding in PCAing that ruling. Moving on now to Mr. Larson as a witness. The case law is clear that, and it's cited in our brief, and it was cited in the trial judge's order, and it's in Furman v. Furman, which is a decision by this court back in 2018, that the rules regulating the Florida bar do not mandate an attorney's automatic disqualification when he or she is called to testify by an opposing party. So only if that testimony is necessary, and necessary has been defined by this court and other courts as you're the only witness who can testify to this matter. In particular, in this case, Mr. Johnson is going to testify to all the financial matters. Both sides have forensic accountants that are expected to testify about all the financial matters and business matters. There's also a firm accountant that represents the law firm who does their accounting that can testify to all the financial aspects that former wife may need to discover during the trial of this case. And then even if all that applied, which it doesn't, the wife is still not shown, as required by this court, that Mr. Larson's testimony would be, quote, adverse to the husband's or assert matters that are contrary to the husband's anticipated testimony. This court and other courts around the state have found that those are prerequisites to disqualify an attorney from his representation if he's going to be a witness. It's simply not the case here. Here, it's being used to exclude Mr. Johnson's chosen counsel a year after he made an appearance, now a year and a half after he made an appearance, and is continuing to prepare for trial, which until recently was set for next month. And Mr. Johnson, as Mr. Manny said in his presentation, the parties need this decision to be over. They need this matter behind them. And we're trying our best to go forward and try the case. And Mr. Larson should be the one who tries it. He's the one that's prepared to do it. He's the one that's reviewed all the documents. He's the one that's taken depositions. He's the one that's appeared and argued at the hearings. There's no reason that he should be disqualified from proceeding as counsel in this case. And I briefly pointed on the fourth reason during my initial presentation, and that is there's simply no record provided. Mr. Manny told this court that Ms. Johnson wants to call Mr. Manny as a witness, but there's nothing in the record that establishes that. There's nothing in the record that he's going to call Mr. Larson. There's nothing in the record where Ms. Johnson testifies that she needs him as a witness. There's nothing in the record to support that in any way. In short, we ask that the judgment of the trial court be affirmed, first and foremost, because they waived their ability to do so by waiting more than a year. All the reasons that are being made now in support of their motion to disqualify Mr. Larson were readily known to them a year ago when he made his initial general appearance. Number two, there was no attorney-client relationship. And the law of the case doctrine doesn't apply to this situation. It doesn't apply to findings of fact. It doesn't apply where the facts change. And it certainly doesn't apply where it's not necessary to the ruling of the appellate court. Third, Mr. Larson is clearly not an indispensable and necessary witness as contemplated by the rules and contemplated by the case law. And finally, there's just no record to support disqualification in this case. I thank you for your time, Your Honors, and I'll cede the rest of my time.
Thank you, Mr. Anderson. Mr. Manny, you
Thank you, Your Honor.
How much time you wanted for rebuttal, but if you want to take about 5 minutes or so.
That's the most I'll take, Judge. Thank you very much. Let me point out a couple of things. I keep hearing an asseveration to the effect that there is no testimony that Mr. Larson was counsel for this wife. I think we've seen, and that's why I was trying to read at the very beginning, that there are record findings made at the very initial 12.540 proceeding that Mr. Larson gave this wife legal advice. And there's no question but that Judge Stevens made that finding that she received legal advice from Mr. Larson not to seek an attorney. And he made that finding. Now that's a 12.540 proceeding. And what happened? Judge Stevens set aside the final judgment that had been entered as a result of the 12.540 proceeding, from which the husband took an appeal. He failed in that appeal. The case was affirmed per curiam. That meant he was stuck with commencing a proceeding to try a case in which there had already been a determination made by a trial judge in that particular case that Mr. Larson had given the wife legal advice. That case was then tried before Judge Nielsen. That case, too, was appealed. There was a reversal and a remand, and it went all the way back to the trial court. But in the meantime, the husband went up to the Supreme Court. The Supreme Court refused to touch the position of the Second District Court of Appeal. That means the case was remanded, and it's as though nothing had taken place. That's what reversal with remand with no instructions means. So they're starting out again right where they were, exactly as they had been when Judge Stevens set aside the final judgment. So that the case started out with a proceeding and a finding of fact and a conclusion of law that Mr. Larson represented the wife by giving her legal advice. I have then answered Judge Lucas' question with respect to, well, Dave, what about what she said at her deposition? I've invited your close scrutiny of what was asked at the deposition. She did think she was not receiving legal advice at first. She further explained that in her testimony, that she thought that he was her friend and that was doing the best for her friend. She didn't think of him as an attorney at the time. It turned out he was very much being an attorney, acting on behalf of his partner, telling her, don't get an attorney, just do what he says and it'll be in your best interest. That's all there before you. Then when it came back now, we're seeing a situation where at the time of the Supreme Court hearing, he files a notice of appearance. And we assume quite correctly, that's just a formality. He's trying to help out his partner. I didn't notice it was Judge Stevens there. I'll be honest about that. But then he files another one. Is it a satisfactory answer that he filed another notice of appearance because no longer had this fellow named Stevens with him? I think not. I don't think that changed a thing. We could technically have been charged in with knowledge of what he was going to do, notwithstanding the fact that this case is right back where it was after the reversal by Judge Northcutt. The case is now starting out again at the very beginning, and we have a finding by the trial judges that have been involved that there was clearly a representation by this man of the former wife in the early part of the proceeding. Now, what do we do in a case like that? I would submit to you, forget law of the case. We're talking about the inherent power of a trial judge to rule with respect to a proceeding before him. Can you imagine what would have happened if Mr. Larson had appeared before Judge Stevens after Judge Stevens made this finding? And yet that's exactly the same attitude that must be evinced when you're trying to make an appearance at this point. Never mind waiver. Waiver is not really important in a case of this length, this time, and of this complexity. I don't think waiver has anything to do with it. No, truly, when I hear there's no record, what could be more important than what we made as a record, which is the final judgment of the case, and that was made by the trial judge himself, setting aside the order on a motion for 12.540 relief. Under these circumstances, may it please the court, you have no real alternative but to reverse this decision. Thank you very much for your attention.
Thank you, Mr. Manning. Thank you, Mr. Anderson.
Are we dismissed, Your Honors?
Yeah, I'm sorry.
Sorry.
Generally, you would have been removed already and the new people in, so I don't know what's going on, but
Thank you.
you're welcome to go. Take care, Mr. Manning.